Okay, good afternoon. This is Judge Alyssa Perez presiding over the 210 District Court criminal docket for December 6, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call this case, calling cause number 2020-0D03257, State of Texas versus Jesse Garcia. May I have announcements, please?
Samantha Rogg on behalf of the state ready, Your Honor.
Edward Hernandez, Deputy Public Defender with the Mental Health Unit, on behalf of Mr. Jesse Garcia. We're ready to proceed, Your Honor.
And we are scheduled today for a pre-revocation hearing. Mr. Hernandez had mentioned he was working on some things about trying to come up with a solution here, Mr. Garcia. And my understanding from your attorney is that part of the screening process, they're going to be unavailable until Friday of this week. So what I had discussed with your attorney is that we could reset one more week to accomplish what he needs to do, and that's what we're going to do. Is that your request, Mr. Hernandez?
It is, Your Honor. I will be, that's why we got the contact visit order signed. I'll be meeting with the client during the screening on Friday.
So this will be reset 1 week, 3 p.m. docket.
Thank you,
you very much. Okay. All right. So now I'll rely on you, Mr. Serna. Who's next?
Yes, Judge. Okay, if we're ready on the pleas, we do have Mr. Joseph here on David Daniel.
Okay.
Can you bring him up, please?
Good afternoon, Judge.
Good afternoon.
Annex, did you hear David Daniel?
What was that again, sir?
David Daniel, David Brooks Daniel.
He's coming up.
Thank you.
David Brooks.
Mr. Daniel, is that you?
Yes, ma'am.
Okay, let's go ahead and get started. I'll go ahead and call him, Victor.
Okay.
Calling cause number 2022-0D02932, State of Texas versus David Brooks Daniel. May I have announcements, please?
Samantha Rogg on behalf of the state ready, Your Honor.
John Joseph on behalf of the defense, and we are ready to proceed, Your Honor.
Mr. Joseph, do you recognize your client appearing from the jail annex?
I do, Your Honor.
Mr. Daniel, I have us scheduled for a plea today. Is that your understanding of what we're doing?
Yes, ma'am.
Okay, in order to get started with your plea, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record, please?
David Brooks Daniel, and it's 10/31/81.
Mr. Daniel, as I mentioned, we're scheduled for a plea today, so there should have been documents that you reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Daniel, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Joseph, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do, Your Honor.
Mr. Daniel, you're satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Joseph, any reason to believe that your client is not presently competent to enter his plea?
Not at this time, Your Honor.
Mr. Daniel, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to do your plea. Sir,
Yes.
are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Here in the United States in El Paso.
In El Paso, Texas?
Yes, ma'am.
Okay, so in this case, you're charged by indictment with the third-degree offense of injury of a child or elderly or disabled person, bodily injury to that charge, sir. What is your plea, guilty or not guilty?
Not guilty, I guess, not guilty.
No, well, those are very different. Guilty means you did it. Not guilty means you didn't do it.
Guilty.
Do you need any time to speak with your attorney?
No, ma'am.
Are you pleading guilty because you are guilty and for no other reason?
Yes, ma'am.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. Rago, would you summarize the evidence, please?
Yes, Your Honor. State of Texas versus David Daniel and cause number ending in 2932. If the state of Texas were to proceed a trial, the state would have proven beyond a reasonable doubt that on or about the 16th day of July, 2022, in El Paso County in the state of Texas, the defendant, David Brooks Daniel, did then and there intentionally or knowingly cause bodily injury to Harry Daniel, an individual 65 years or older, by placing Harry Daniel in a bear hug and squeezing Harry Daniel with the arms of the defendant. The recommendation, Your Honor, is FOD deferred, $2,000 fine, probate the $2,000, 300 hours of community service, TAP assessment, anger management, no offensive contact with Harry Daniel. At this time, the state moves to enter into evidence States Exhibit 1 and 2 if there's no objections.
No objection, Your Honor.
States 1 and 2 are admitted. Mr. Joseph, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Daniel, is that your understanding of the plea agreement?
Yes, ma'am.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Daniel, do you recall reviewing that document with your attorney and signing that document?
Yes, ma'am.
Finally, the motion for deferred adjudication. Mr. Daniel, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, ma'am.
Mr. Joseph, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Your Honor.
Mr. Daniel, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for this offense? Do you understand
Yes,
that?
ma'am.
And are you asking the court to grant you deferred adjudication?
Please. Yes, ma'am.
I will find that there is sufficient evidence to substantiate a finding of guilt in this case. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 5 years. There will be a $2,000 fine. $2,000 of that is probated, which means as long as you are in compliance with your probation, you won't owe that fine. If you are not in compliance, then they can collect the entirety of the fine. 300 hours of community service, TAP screening, anger management, no offensive contact with Harry Daniel. Is there anything further, Mr. Joseph or Ms. Rago?
Nothing from the state, Your Honor.
Nothing further from the defense, Your Honor.
Good luck to you, Mr. Daniel.
Yes, ma'am. Thank you.
Thank you. All right, who's next?
Judge,
you, Your Honor.
okay.
Thank
Judge-
you.
Judge,
Sunday.
would you like to get Mr. Ivy out of the way in reference to trial?
Sure, the motion for continuance. So who's that?
That is on page 14.
Okay, Gabriel Ivan Caballero, annex, please.
Caballero? Yes,
Yes, sir. Thank you for logging in, Mr. Ivy.
Of course, Judge.
Is that you, Mr. Caballero?
Hey.
Is he a Spanish speaker?
Yes, Judge.
Yeah, okay. Do we have our interpreter yet?
Not yet, Judge.
Oh, sorry.
It would.
Okay, we'll have to wait. Sorry about that.
Okay.
No problem.
Who's next?
Yes, Annex, can we have De La Vega Henry?
De La Vega, Henry? Yes, sir. De La Vega.
Mr. De La Vega, is that you?
Yes, ma'am.
Okay, go ahead and call it. Calling cause numbers 2022-0D00326 and 2022-0D00351, State of Texas versus Henry De La Vega. May I have announcements, please?
Samantha Raug on behalf of the state, State Tribunal, Your Honor.
Pedro Hernandez, Deputy Public Defender with a mental health unit, on behalf of Mr. Henry de la Vega. We're ready to proceed, Your Honor.
And Mr. Hernandez, and Mr. De La Vega is appearing from the jail annex remotely. I think where we had our last substantive hearing was at our 2801. That's what I'm looking at anyway on 0326. Is it fair to say we just need to get a new trial track here, or are you working on something else?
That's correct, Your Honor. My client was found competent, and we're requesting a trial track. I would ask for another 2801 since the last one kind of got derailed.
Okay, so let me see, Myrna, what's our next like regularly scheduled trial opening? Do you remember, Mr. Hernandez, was this in terms of the evidence, things of that nature? I don't have a problem redoing a 2801 deadline, but is it something that you're gonna wanna, I'm not gonna say expedite, but sooner than later?
Yes, Your Honor. I wouldn't want to leave my client in
Right.
jail any longer than he has to be, you know.
Yeah, so let's see if we can do something, if we can squeeze them in March or April, Myrna, I don't know how.
I was gonna say February, Judge.
Oh, if we have something in February, let's do that.
That'll work, Your Honor.
And then, while we're looking at that date, Mr. Hernandez, I'm gonna put the 2801 hearing on January 10th.
That's fine, Your Honor.
At 10 a.m. And then let's see what we have and we'll go from there. Do we know of anything outstanding right off the bat?
We have to just work up the factual evidence, Your Honor. I don't anticipate it'll take too long.
Okay. Because if we have a February trial date, that'll be a really quick turnaround. So I don't know if we'll have motions to suppress, anything like that. We'll have to be very diligent about getting them scheduled.
Yes, Your Honor.
Okay.
Does the court know roughly what day in February, Your Honor, just so I can?
I don't. Let me
to
see
the-
what Myrna tells me. I'll get on there as well. I think February is, I feel like it's tricky, but let's see. Do you want to be specially set, Mr. Hernandez, or?
Sure, Your Honor. I'd have to look at what else is set out there, but I will take a special setting.
Judge, I was looking at the 24th, but that has a special setting. Let me go back.
And if I may just advise my client, in the meantime, Your Honor, Mr. De La Vega, a special setting means that we go. If we tell the court we're going to go, that's the day we go. Instead of being behind somebody else and possibly getting pushed back.
Yeah, I don't know, Myrna. I feel like all the way through April, we're like tight.
Judge, February 10th doesn't have any special settings.
Let me look at it. A lot of cases. Okay.
That works for me, Your Honor.
February 10th. Ms. Rago, any issues you can see offhand? So that means our 2801s are, yeah, only a month before. So you'll be specially set on that day. Myrna, would you make sure that you give Mr. Marufo, I don't know if we already have our panels requested for that day. In the event that we don't, we need to make sure we do have them, and it'll probably be 2 panels on that day. I don't think we'll need more unless we already have them, okay?
Judge,
So we'll do
starting
it
on Thursday for jury selection?
I don't think, I mean, do you all think you need 4 panels? Or can you do it with 2? 2 panels of 60.
I think we can do it with 2 panels, Your Honor.
I think
I
so.
think so too. I
Okay.
think so too. So whatever we have just on Friday.
I'll let him know.
Thank you. Okay. All right, then we're good to go. We have our dates.
Thank you, Your Honor.
Thank you very much. Who's next?
Annex, may I have Dominguez Mark?
Yes, sir. Give me 1 second, sir.
Thank you.
All right, I'll go ahead and call it. Calling cause number 2022-0D03571, State of Texas versus Mark Dominguez. May I have announcements, please?
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Dennis Moore from Mark Dominguez, ready to proceed, Your Honor.
And Mr. Moore, do you recognize your client appearing from the jail annex?
Yes, Your Honor.
Okay, we're scheduled for a bond hearing today. You may proceed.
Thank you, Your Honor. Mr. Dominguez is booked on 2 counts of engaging in organized criminal activity. Those are indicted as first degrees. The bond is at $200,000. Mr. Dominguez is 17 years old. He's been in jail now since August the 30th. So that's I guess over 2 months. He was born in El Paso. He's lived his whole life in El Paso. He lives at 447 South Schutz Street, apartment 247, with his mom and his sisters. And I've spoken with his older sister, and he's still welcome to live there. He was attending school at Isleta High School, and he had been due to graduate next year. He has no adult history, obviously being only 17 years old. I think his only juvenile history is an assault that was dismissed. He has no children. He's never been married. His family only has a minimal amount of money to post a bond with, maybe just a few $100s. Even though these are filed as first degrees, it's really not, I don't know, it doesn't seem like a first degree case. Basically, the allegation is that he and some other kids basically confronted a couple kids at a park, and the allegation is that they took some chains off the neck of one of these kids, and one of the kids had a knife and one kid displayed a firearm. Now, this incident wasn't reported when it happened. It actually came to light over a month and a half later. And then also, it's very clear in the state's report that no one alleged that Mark Dominguez possessed a gun. No one alleged that he possessed a knife. He didn't have a weapon at all. And no one alleged that he took anyone's property. The kids he was with did those things. And then when the police found the property, it was with one of the other kids, not Mr. Dominguez. And as far as the allegation of gang involvement, there's nothing in the state's file that reflects that my client has any gang involvement or gang history apart from the things that were said that day. So I think this is maybe something that could be handled with a bond. I'm hoping of something, maybe in the $1,000 to $2,000 range. I would ask for a full PR bond, except that I think that's impossible under the statute. But due to his age, the nature of the actual allegations, his lack of criminal history, his, living his whole life in the community, we're hoping that Your Honor could reduce his bond to something of that nature.
Okay, thank you, Mr. Moore. Ms. Rago?
Yes, Your Honor. So the defendant does have the juvenile criminal history. It was an assault. He was placed on deferred and was ultimately dismissed. There was three individuals that were involved in this incident. The allegations are in reference to a street gang. In addition, a knife was pulled, in addition to a firearm. We had one of the other co-defendants this morning that indicated they had an alibi as well. And so unfortunately, it seems like everyone's kind of pointing fingers on who actually had the gun and who had the knife at that point. The state is concerned just because it is gang affiliation. And they indicated that this defendant yelled the gang during this incident. And so the state is concerned for the victim at this point, Your Honor.
Your Honor, if I may, I would like to point out that in the state's report, the two alleged victims were very specific in their statements about who had the knife and who had the gun. I think the one with the gun was Aldonis, another kid, and the one with the knife, I think, was Badillo. So going just by the state's report and what the alleged victim said, my client did not have a gun or a knife or grab anyone's chains, necklaces off of their neck. Though according to them, he was present.
Okay. Yeah, I just can't get there, Mr. Moore. The request for a bond reduction is denied. Thank you very much.
Thank you, Your Honor.
Mr. Dominguez, who's next?
Yes, Judge, Annex, may I have Maldonado?
Maldonado.
Yes, sir.
Maldonado.
Good morning. I mean, good afternoon. It's been
No,
one of those days, right, Judge?
I did that yesterday. I didn't take a lunch, so when I left for lunch, it was like 3 in the afternoon, and I told somebody good morning. But that's why, because I hadn't got a lunch, it was still like morning.
It's all
yeah.
topsy-turvy.
On this one, so we have a dismissal on 2352 and then a plea on 2349 and 1967. Is that right?
Yes, Your Honor.
Okay.
Your Honor, we don't have a Maldonado on our docket.
Oh, yeah. Wait a minute. Did we send out for, because that, well, they don't show her in jail on 2349. On 1967? Was that not, was she not requested? Or is she at the downtown jail? Or do we
I've
know?
always been at the annex when I've met with her, Your Honor.
Yeah.
Only one of her cases showed that she was in jail, Judge. The others,
I know.
why? She is.
Can someone, is she supposed to be at the annex?
I'm sure she's there. Well, I mean, I
So
guess
let's,
it's possible she's bonded out, but
so we have a booking number, right? Oh God, I don't know which one it is. Which one is it?
Yes, Judge. I'm showing 9687810. It's her SO number. That's what I'm showing for the one that she's actively booked on, and she is in the annex.
yeah, I'm showing she has not been released.
So annex, is it possible to get her with the booking number 9687810? And she has a different booking number, right, on the other two cases?
Also got her SO number.
Yeah, that sounds better.
In the meantime, if we can go to Manuel Martinez, unless, does that one need an interpreter also?
He does not need a interpreter, Your Honor.
While we're waiting on is that Mr. Martinez, Manuel Martinez?
It is, Judge. And before we get into the plea, can I just tell you kind of the status on this case? Because we had been considering sending him to the BHRTC. I got communication back from the probation officer that he didn't meet the qualifications to go to the BHRTC. So she's looking at the drug court and something other as well. I asked her why he didn't meet the qualifications, and she said her email to me was that I just received this yesterday, that he has not, I guess he has not gone through the outpatient places yet to to really meet those qualifications. And I guess the outpatient stuff would include the drug court. And as stated by the probation officer, well, it's a 384 drug court.
So I think we had a hearing back in October, and Carla, are you there? I think I was pretty clear that I wanted him to go to BHRTC. I did see the case summary coming back with a screening for the 384th drug court, but I mean, I'm at BHRTC, plain and simple. So he either goes to BHRTC or we can go with the 2 TDC.
Well, he did agree to go to the BHRTC, and we set up the plea for purposes of him going to the BHRTC. I was just told that he didn't qualify, but if I also I understand from the last email that if you order it, they will take him.
Right. So
okay.
That's kind of where I was when I saw the plea paperwork come in on this one. I thought we were pleading him out so that we could get him onto BHRTC, get him on the list. Carla, you can send me whatever documentation you all need to get him to BHRTC, right?
Yes, Your Honor.
Okay, so that's what we're doing.
Okay.
I hear you, Mr. Anderson. I know that's kind of where probation has been recommending, but I think I'm not deviating from.
He agreed to that, Your Honor. I was just concerned that maybe he wouldn't be able to get in. That's why I wanted to raise that, but
Sure.
he can get in. He has agreed to accept that treatment now.
Okay, all righty. So then if everything is good with that understanding, is everybody ready to get started?
Yes, Your Honor.
Okay, calling cause number 2020-0D04362, 2020-0D05268, and 2020-0D05269. All cases filed the state of Texas versus Manuel Martinez. The 2020 cases are the probation cases that we were discussing briefly off the record, Mr. Martinez. But in the 2022 case, I do have plea papers here indicating that you want to plea. Is that your understanding of what we're doing here today? Mr. Martinez? Okay, sorry, I need to have verbal answers and make sure you speak loudly enough so we can hear you, okay? With that, then on the 2022 case, let's get started with your plea. Would you please raise your right hand? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, sir.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record, please?
Martinez, September 25, 1994.
Mr. Martinez, I'm going to ask you just to speak up a little bit louder, okay? Because it's a little hard to hear you.
Manuel Martinez, September 25, 1994.
Mr. Martinez, as I mentioned, I have documents here related to your plea, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Martinez, do you recall reviewing those documents with your attorney and signing those documents? Mr. Martinez, I need a loud verbal answer.
Okay, Your Honor.
So do you recall reviewing the plea papers with your attorney and signing those documents?
Yes, Your Honor.
And did you understand everything contained within those documents?
Yes, Your Honor.
Mr. Anderson, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
I believe he's understood the admonishments, rights, and consequences of giving up these rights by entering his plea today.
He did, Your Honor.
Mr. Martinez, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Mr. Anderson, any reason to believe your client is not presently competent to enter his plea?
None.
Mr. Martinez, have you ever been found mentally incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, Your Honor.
Okay, in this case, you were charged, although you were charged by indictment with the felony, let me find it, felony offense of burglary of building. I understand that through negotiations, you were pleading to the lesser included Class B misdemeanor offense of theft of property in an amount between $150 and $750. To the Class B misdemeanor theft, sir, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily? Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Ms. Rago, would you summarize the evidence, please?
Yes, Your Honor. State of Texas versus Manuel Martinez and cause number ending in 4362. If the state of Texas were to proceed to trial, the state would have proven beyond a reasonable doubt that on or about the 21st day of August 2022 in El Paso County in the state of Texas, the defendant Manuel Martinez did then and there intentionally or knowingly enter a building or a portion of a building without effective consent of Sunglasses Vision Center or Walmart, the owner thereof, and attempted to commit or committed theft of property. Your Honor, the plea agreement is a reduction to Class B misdemeanor, 100 days credit for time served. At this time, the state moves to enter into evidence States Exhibit 1 and 2 if there's no objections.
No objection, Your Honor.
States 1 and 2 are admitted. Mr. Anderson, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. Martinez, 100 days, is that your understanding of the plea agreement as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Martinez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
Signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the Class B misdemeanor theft, and I will sentence you according to the plea agreement to 100 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further on this case, Ms. Rago or Mr. Anderson?
Nothing from the state, Your Honor.
Okay, so with that case resolved, I'm sorry, Mr. Anderson, go ahead.
No, I think you're getting ready to talk about the probation case, aren't you?
Right. So with that case, with the 2022 case resolved, Mr. Martinez, now the court will be referring your 2020 cases or modifying your probation to get treatment at a residential facility, BHRTC. So your probation will be modified. Do we know how long he is on for, Carla? How much more, or when is he supposed to be done with probation?
We still have him, Judge, through 2026.
Okay. All right. So if you have any questions regarding that, there is a waiting list, Mr. Martinez. So that was kind of the urgency in getting this case resolved so that they can actually have you on the waiting list, which I can't give you an amount of time. It takes usually a matter of weeks. So once there becomes space available, then you will be placed there, okay?
Okay, Your Honor. Thank you.
All right. Thank you very much, Mr. Anderson. Anything else?
Nothing further, Your Honor.
Thank you very much. If you don't have any, oh, well, you have something else. Okay, who's next? Thank you, Mr. Martinez.
Yes, Annex, may I have Navarro 1, please, with Mr. Lopez?
Bravo.
Oh, and Ms. Melendez, you're here instead of Ms. Nieto. I'm so sorry. I didn't realize that.
Yes, Judge.
Sorry. Okay. 1 second. Mr. Navarro, okay. Calling cause number 2018-0D03194, State of Texas versus Juan Antonio Navarro. May I have announcements, please?
Samantha Rago on behalf of the state. State's ready, Your Honor.
Your Honor, Luis Lopez on behalf of Mr. Navarro.
And Mr. Navarro is appearing remotely from the jail annex. We are scheduled for a pre-revo hearing on this one. Can you all refresh my memory a bit?
I've been putting together a mitigation packet to present to Ms. Rago so I could discuss with her the different options that may be available to Mr. Navarro. Unfortunately, Your Honor, this past week, we lost our email accounts. Our server is now being held hostage by ransomware. And so, yeah, Rackspace has thousands of email subscribers have had to switch over to Office 365. in any case, we're trying to dig through all of our emails to get all of our archive files, because that's how his parents were sending us, his wife and his family were sending us emails. So it's going to take me about, I would say, 15 days to get everything back from all the stuff that we lost. I'm going to have to ask him just to resend it. And once I get it all, I'm going to forward it to Ms. Rago, and then hopefully that'll be something that she can review, and then we could discuss what to do.
Okay, so unfortunately, just because of scheduling, I probably can't get you in here until the 17th. Yeah, January 17th at 3 p.m. Okay, that's the closest I can get you here. I mean, if you have something where you all are discussing something else and want to inform the court, but in terms of a hearing, getting you back here, I can get you back to the 17th.
I understand, Your Honor. Hopefully we'll get everything that we need, and I get it to Ms. Rago. And if we can resolve this in any shape or form, I will notify the court immediately.
Okay, thank you so much. All right, let's go to the next one. Good luck with that. That sounds crazy.
Thank you, ma'am.
Let's go to David Torres. Annex, can we have David Torres? Mr. Darnell, are you there?
I'm here, Judge.
Okay. Let's see if we can get your client. That Mr. Torres?
Yes, ma'am.
Okay, calling cause number 2021-0D00324, State of Texas versus David Torres. May I have announcements, please? Sorry.
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Jim Darnell for David Torres. We're ready, Your Honor.
And Mr. Torres is appearing from the jail annex. We are scheduled for a final hearing plea deadline, and just to be direct, I think you all are our only trial. So let me hear your rec, Ms. Rago.
Let me pull it. Rec is 10 to do, Your Honor.
Okay. Mr. Darnell?
Judge, this is one that is become a lot more complicated. As the court knows, there are two Romeo and Juliet statutes. One applies to the substantive offense and is not retroactive. The other applies to the obligation to report as a sex offender, which is retroactive. Both statutes were passed after he was convicted when he was much younger, much younger. And so it looks to me like we've been in touch with the complaining witness, and I had reported that to the court before. He should be eligible to have the obligation to report removed retroactively, but I believe that has to be done by a court in Tom Green County, San Angelo, which is where the offense originally occurred and where the complaining witness still lives. So as best I can tell, I need to get back with her one more time to firm up some facts. I think we're going to have to file a writ in Tom Green County, and the outcome of that writ will be outcome determinative here.
Okay, but I mean, I feel like this has been outstanding for a while, and I think we reset from about, let me see. We reset from about 2 weeks ago, I would think. Let me look.
Right, and at that point, we had talked to the complaining witness, and we need to get back with the complaining witness. And we're waiting to get some documentation back from her. And frankly, I think I'm going to have to drive back to San Angelo to talk to her.
Well, yeah, I'm not inclined to move it. I'm not really, I'm not there. So if you want to file a motion or file something else, Mr. Darnell, please let me know ASAP if you think it's going to affect something, but we're set for trial on Friday.
But Your Honor, this is a case, we are set for trial, but this is a case where his obligation to report should be removed by the court in Tom Green County, which means he would not be subject to a crime here. And it would be removed back to the time when the offense happened.
Mm. Yeah, but this case got indicted February of 2021. So it's almost 2 years old. We had our first trial setting beginning of 2022. We went back August. I want to say the first time I hear of this is at the November final hearing plea deadline. I mean, it's not time.
That was the first time we had actually been in face-to-face contact with the complaining witness. I had spoken with the complaining witness, but we'd had face-to-face contact. Once we get this paperwork signed, I think we will be in a position to file the writ, get the paperwork filed, and we will get a ruling in Tom Green County that will tell us he is subject to having to register or he is not subject to registration, going back all the way 25 or 30 years ago.
Okay, well, I'm not going to move the trial setting. If you want to file something and you want me to rule on it, we can reconvene on Thursday morning. We're set for trial. Okay.
Okay.
Thank you very much. Who's next?
Yes, Judge.
Daniel Valles, since I'm
Yes.
seeing it on this page.
Okay, thank you.
Annex, if we could have Mr. Valles, please.
Yes, ma'am.
Judge, I'm texting council of judges in reference to our interpreter.
Oh, okay. That seems like a while. All right, let me call it 2019 0D0 4292, State of Texas versus Daniel Valles. May I have announcements, please?
Roa King and Michelle Hill for the state. State is ready. Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Veronica Teresa Lerma on behalf of Mr. Valles.
And I'm sorry, Ms. Lerma, are we expecting Mr. Lerma?
Oh, Judge, no, I'm sorry. We're not.
Okay.
It'll just be me today.
Okay, so we are
If that's
scheduled.
okay with the court.
Yeah, that's fine. We're scheduled for a status conference. Mr. Valles is appearing remotely from the jail annex. I gotta feel like I was checking in with you all on that phone dump. So State, do you have an update?
Yes, Your Honor. As of yesterday, I did reach out to Special Agent Yanez from HSI, and he did inform me that as of yesterday, there was they were not able to get into the passcode just yet. So the system is going to keep on trying. But as of right now, that's it. There's still no other updates.
So nothing sooner. There's no update in terms of, we already scheduled this down the road. Ms. Lerma, do you have anything you want to ask? Anything that's come up?
Yes, Judge, I'm going to be in touch with Ms. King and Ms. Hill regarding the iCloud information. We've been in touch with Apple and we were able to confirm, I kind of on a cursory basis talked to them about this, that they can access whatever is on the cloud, not the actual phone, but they can access what's on the cloud and saved in the cloud without need of the phone, should they have the family member's signature. So I'll provide them all that information, and that might be
faster.
Another way to get at least some of the information on the phone. It may not get whatever's on the hard drive, and that can just continue with HSI. I'll send them that information.
Okay, we have a final status in January, and then there's a good window before we come back. We'll address if there's a reason to come back if we need to before then, and obviously if before January 31st you all need a hearing on something, please let us know. Yeah, I had forgotten how far down the road we were on this one. Has there been anything else, any change in the rec, anything different?
No, Your Honor.
No. Okay. All righty. If you all don't have anything further, just let us know if you need a hearing outside of what we have at this point.
Thank you, Judge.
Thank you, ladies. Take care.
May I be excused?
You may.
Thank
Who's
you.
next?
Good
Annex.
afternoon.
Okay.
Bye-bye.
Bye.
Annex, do we have Maldonado after all?
Yes, sir.
Okay, thank you, sir.
Okay.
Is that Miss Maldonado?
Thank you.
Yes,
Bye-bye.
Okay, are you all ready?
Ready you are.
Yes, okay. Calling cause numbers 2022-0D02352, 2022-0D02349, and 2022-0D01967. All cases styled State of Texas versus Melissa Maldonado. May I have announcements?
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Greg Anderson on behalf of Ms. Maldonado, ready to proceed, Your Honor.
And Ms. Maldonado is appearing from the jail annex. Ma'am, it is my understanding that although all three of these cases were set for a plea, I think one of them is actually getting dismissed, the cause number ending 2352. But on 2349 and 1967, I do have documentation indicating that it is your wish to plead on those cases today. Is that your understanding?
Yes, ma'am, it is.
Okay, so I need to swear you in so we can get started with your pleas. If you would raise your right hand. Ma'am, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am, it is.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Yes, Judge. It's Melissa Maldonado, 7/14/1987.
Ms. Maldonado, as I mentioned, there are documents related to your plea, the first of which for each case is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Maldonado, do you recall reviewing State's Exhibit number 1 with your attorney and signing those documents?
Yes, ma'am.
Did you understand everything contained within those documents?
Yes, Judge, we do.
Mr. Anderson, have you had more than 10 days to prepare defenses in these cases?
I have, Your Honor.
And did you explain the plea papers to your client?
I did explain them to her, Your Honor.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering her pleas today?
I do.
Ms. Maldonado, are you satisfied with your attorney's representation of you?
Yes, ma'am, I am very satisfied.
And Mr. Anderson, any reason to believe that your client is not presently competent to enter her pleas?
No reason to suspect that, Your Honor.
Ms. Maldonado, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Ma'am, are you a U.S. citizen?
Yes, ma'am, I am.
Where were you born?
Here in El Paso, Texas.
Okay, so in cause number ending 1967, you are charged by indictment with 2 counts. The first count is theft of property in an amount between $2,500 and $30,000. That's a state jail felony. Ma'am, to that charge, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
In count 2, the charge is burglary of habitation. That is a 2nd-degree felony. What is your plea? Guilty or not guilty?
Guilty, Your Honor.
In cause number ending 2349, you were charged with the state jail felony theft of property in an amount less than $2,500, but with 2 or more previous convictions. To that charge, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making each of your pleas freely and voluntarily?
Yes, Your Honor.
I will find you are making your pleas freely and voluntarily. Ms. Rago, would you summarize the evidence, please?
Yes, Your Honor. State of Texas versus Melissa Maldonado and cause number ending in 2349. If the state of Texas were to proceed to trial, the state would have proven beyond a reasonable doubt that on or about the 19th day of June, 2021, in El Paso County, in the state of Texas, Melissa Maldonado did then and there unlawfully appropriate or acquire and otherwise exercise control over property other than real property, to wit, dogs, a blue heeler canine, and a pug canine of the value of less than $2,500 without the effective consent of the owner, namely Iris Martinez, with intent to deprive said owner of said property. Now moving on to cause number ending in 1967, State of Texas versus Melissa Maldonado on count 1. If the state of Texas were to proceed to trial, the state would have proven beyond a reasonable doubt that on or about the 7th day of March, 2022, in El Paso County, in the state of Texas, Melissa Maldonado did then and there unlawfully appropriate by acquiring or otherwise exercise control over property other than real property, to wit, a Toyota motor vehicle of the value of $2,500 or more, but less than $30,000, without the effective consent of owner, namely Joshua Young, with the intent to deprive said owner of property. Now moving on to count 2 and cause number ending in 1967. If the state of Texas were to proceed a trial, the state would have proven beyond a reasonable doubt that on or about the 7th day of March, 2022, in El Paso County, in the state of Texas, Melissa Maldonado did then and there intentionally or knowingly enter a habitation without the effective consent of Laura Sines or Joshua Young, the owner thereof, and attempt to commit or committed theft of property. The plea agreement, Your Honor, is for count 1 ending in 1967 and cause number ending in 2349 is 5 years deferred, which are the state jails, and on count 2 and cause number ending in 1967, 8 years deferred, $1,000 fine, probate the $1,000, 100 hours of community service, $2,100.74 to Laura Sines, court costs, UABA, theft course, life skills course, and cause number 2022-0D01967 and 2022-0D02349 are to run concurrent with the dismissal of 2022-0D02352. At this time, the state moves to enter into evidence exhibit 1 and 2 if there's no objections.
No objection, Your Honor.
States 1 and 2 are admitted in each case. And Mr. Anderson, is that your understanding of the plea agreement?
It is, Your Honor.
And Ms. Maldonado, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights because these are plea bargained or negotiated cases. You do not have an automatic right of appeal. Ma'am, do you recall reviewing the trial court certification with your attorney and signing those documents?
Yes, I do.
Finally, the last document, the motions for deferred adjudication. Ms. Maldonado, did you review those with your attorney and sign those documents?
Yes, I did, Your Honor.
Mr. Anderson, did you explain to your client both the benefits and detriments of deferred adjudication?
I did, Your Honor.
Ms. Maldonado, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for each of these offenses? Do you understand that?
Yes, Your Honor, I do.
And are you asking the court to grant you deferred adjudication?
Yes, Your Honor.
Okay. I will find in each of these cases there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement in count 1 of 1967 and as to cause number ending 2349, 5 years deferred adjudication. In count 2 in 1967, it is 8 years of deferred adjudication. In each of these cases, the fine will be $1,000 that is suspended or probated as long as you're compliant with your probation. They won't collect the fine. 100 hours of community service, restitution in the amount of $2,100.74 to Laura Sines, court costs, urine and breath analysis, curfew from 10 p.m. to 6 a.m. unless you are working or going to school. You were to attend theft counseling and life, what was it? Life
skills course, Your Honor.
Life skills course. And all other standard terms and conditions and everything runs concurrent. Anything further, Ms. Rago or Mr. Anderson?
Nothing from the state.
As soon as I get the dismissal on cause number 2352, I will sign it.
Your Honor, 2 things. Very briefly, Ms. Rago, if you're interested, my client might be interested in taking responsibility for the co-defendant's case, whose name is Melissa Segura. Myrna Page has approached me, and the client is at least arguably willing to do that if that's something you would consider. And I'll coordinate that if you are interested. Secondly, Your Honor, the jail record looks unusual in that it's not really showing a couple of the cause numbers. But the jail records do show a PR bond for her. So I think she will be released today in light of what I understand. I may need to approach you again, maybe tomorrow if she isn't released, because the jail records are a little bit messed up in light of the fact that she had several cases against her.
Okay. All right. Well, let me know if you need anything. Yeah, I hear you. What else?
Thanks, Judge. Appreciate it. Get back with me, Ms. Rago, please, if you want to go that route.
Will do.
Thank you very much. Good luck to you, Ms. Maldonado.
Thank you, Your Honor.
Thank you, Judge.
Okay,
Bye-bye.
who's left?
Caballero, we're ready, and we do have the interpreter, Judge.
Oh, good. Let's start that function, please.
Good afternoon, Your Honor.
Hey, Mr. Portugal.
Yeah.
It'll be, who is it? Mr. Caballero.
Yes.
Mhm. All right, there he is. Victor, do you have the interpreter function there to start?
I do. One moment.
Okay, thank you. Oh, there it is.
There you go. Should be ready.
Sure.
Wait.
Perfect. Oh, let me find the case. All right, calling cause number 2022-0D00029. I thought there were two cases on him, and I'm thinking I'm only seeing one. So we'll go with that one. State of Texas versus Gabriel Ivan Caballero. May I have announcements, please?
Samantha Rogg on behalf of the state. It's ready, Your Honor.
And I for Gabriel Caballero, Your Honor.
Mr. Ivy, if you're speaking, I need you to select the English channel. Yeah, so the additional cause number in this case is 2022-0D00305. Okay. Mr. Ivy? So if you said, oh, okay, now I can hear you. Okay, so here we go. So we were actually set earlier today because, so you know, Mr. Caballero, your attorney has filed a motion for continuance, and we were specially set for jury trial this Friday. Mr. Ivy, you want to give me the court a quick update on what's going on with the motion for continuance?
Yes, Judge. First of all, an investigator was appointed right after we had the last hearing. I'm not sure which day that was. They're still preparing their report, interviewing witnesses. Additionally, we still need to have the outcry hearing. The outcry hearing was continued the last time we were in court because there were some witnesses that the state needed, I believe. And so we still need to do that before we're ready for trial, Judge.
Okay. Mr. Caballero, were you able to hear, well, you wouldn't hear, you're going to hear the interpreter. Did you understand the reason stated by your attorney about this motion for continuance? Okay, so the court had you specially set for this week, but because you're in custody, the court is going to specially set you again. I don't have a date right now, but we're probably looking at April or May, possibly, of next year. So Mr. Ivy, I'm going to grant your request for continuance, but we need to go ahead and find you a good date, also considering we have to get some other hearings in there. So we will look at that, but the hearing, I'm sorry, the trial setting this week is continued. and we'll get you a new slate of settings going forward. Is there anything else you all needed to cover? Let me ask Ms. Rago, has there been a change in the rec? What's the rec?
The rec, Your Honor, it's going to be dismissal of count 1, 20 TDC on all other counts ending in 0029, and then the dismissal of the drug case, Your Honor.
Okay, alrighty. Well, there we have it. Is there anything further on this one?
No, Your Honor, not from us.
Alrighty, thank you very much. Thank you, Mr. Caballero. Okay, who was the next case that we
Lopez.
needed the interpreter?
Annex, it'll be Mr. Lopez.
Is it Sergio Lopez?
Yes.
Good afternoon, Your Honor.
I think it was Sergio Lopez.
It is.
That's him. Okay. Calling cause number 2022-0D04696, State of Texas versus Sergio Lopez. May I have announcements, please?
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Rick Huffman on behalf of Mr. Lopez, we're ready, Your Honor.
And Mr. Lopez is appearing remotely from the jail annex and utilizing the assistance of court interpreter, Mr. Enrique Portugal. We are scheduled for a bond hearing today. Mr. Huffman, you may proceed.
Thank you, Your Honor. Judge, Mr. Lopez is 31 years old. He's a U.S. citizen. He's basically been living in Houston for the past 10 years. And he's been working kind of on and off with the oil field pipelines. Lately, the latest job he had was in Odessa, but he does travel for work. He doesn't have anybody in El Paso, doesn't have any ties to El Paso. He was basically driving through at the time to go visit his family in Mexico. He has 2 children in Mexico, a 1-year-old and a 2-year-old. Judge, he's been in custody for almost 2 months. His bond totals about 25,000 for the unauthorized use of a motor vehicle and felon in possession of a firearm.
Mhm.
And Your Honor, we're asking the court to consider reducing the bond. He has been found to be indigent. He can afford roughly a $500 bond, maybe a little more. If released, Judge, he does understand that he needs to report to court and abide by any conditions that the court deems appropriate. We're hoping the court would allow him to go back to work in Odessa so that he can provide for his family. And we're respectfully requesting a bond reduction on it.
Okay, Ms. Rocco, go ahead.
Your Honor, the state is concerned about the lack of ties to El Paso. Mr. Huffman just indicated that he was living in Houston for the last 10 years. In addition, he does have ties to Mexico. Mr. Lopez, he does have some criminal history. There was an indecency that was rejected by Live Oak. That was in 2011, driving with a license that was invalid. That was dismissed in 2019. In addition, there was a 2015 burglary of a habitation that was out of Harris County. And so the state is concerned about the lack of ties. In addition, the car that was used for the unlawful use of a vehicle, it was indicated it was stolen out of Midland. So the state is concerned about lack of ties with El Paso, Your Honor.
Okay. What's the rec? Do we have a rec in this case?
Let me see.
Yeah, Judge, we haven't been arraigned yet. I think we're set for an arraignment in January.
Mm.
I don't have a rec yet, Your Honor.
Okay, I would encourage you to look at it, Ms. Rago, because if we're talking probation, I don't know if that's something that Mr. Huffman, I don't know how much you've been able to review it. Based on the history, lack of ties, future safety, I'm going to go ahead and deny the request. The bond is going to remain the same.
Understood. Thank you, Your Honor.
Thank you very much. Do we have anybody left?
Oh, that is it, Judge.
If not, let's get off of YouTube.